here's the thing. Anytime you're swinging a screwdriver at somebody or hitting somebody with the screwdriver, it gets to that point of violence in a relationship, not a good relationship. So your relationship with her is over. How old are you?
I am 43.
All right, so you should know better. So that relationship is over. Here's my advice to you. When you're released from the prison, don't immediately get into another relationship because you're not ready for one.
Yes, ma'am.
He came into court with a serious case already nearly decided. But the real moment came after the plea, when his lawyer raised one request. Not prison time, not the fine, contact. The defense said there was still an ongoing relationship, and even suggested she might want to visit him later. That is when Judge Boyd stopped treating this like paperwork and made the message personal, because in her courtroom, a plea may close the case, but it does not erase what the case revealed.
Court is calling 2024 CR 012116, State versus Jose Ovidio. Could I have parties announced for the record? State,
Rick Pena for the state of Texas.
defense.
Ron Ross.
And how do you pronounce your last name, sir?
Oviedo.
Oviello?
Oviedo.
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 Okay, thank you.
Yes, ma'am.
Counsel, have you received all discovery?
I have, Judge.
And did you review it with your client?
I did, Judge.
Court will find that the state is in compliance with discovery. Is there an application in this case?
No, Your Honor.
All right, sir, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We're waiving the habitual enhancement, Your Honor.
Any objection?
No objections to that.
All right, sir, did you review the document entitled Court Admonishments and Waivers with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, punishment is to be assessed at 2 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon, no applications. The state will take in consideration 2024 CR 012198. There's an affirmative finding of family violence, and there's to be no contact with the complainants.
Judge, that is the agreement. We were going to ask the judge to make that a no harmful contact. He has an ongoing relationship with that lady, and there's still have.
All right, let me ask you all, is this name spelled correctly? You spell it Adnrea?
Yes.
Is that the way you spell that?
Andrea, Andrea.
Adnrea. Is that the correct spelling?
It's misspelled. I'm
All
sorry.
right, what should it be? What's the spelling?
Andrea.
Any objection to the court making that correction in the plea?
No, Your Honor.
All right, did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
All right, and defense, you're saying that your agreement is not for no contact, it's for no harmful or injurious
Well, it
contact?
is for no contact, but we would ask the court to make a no harmful contact. We will go by that if that's what the judge rules.
Okay.
But we're asking you to make that one exception because he does have a relationship with this lady.
All right, state, do you understand that to be the agreement?
That's not the Commissioner. We're asking for no contact, given the facts and circumstances of this. We ask that no contact order go forward.
All right, so they're saying that's a part of their plea bargain agreement. All right,
You want to go ahead and go with no contact with him? That's what the plea bargain is.
I mean, that's very exciting.
Willing to go on to, okay, you can always pull back. But you.
all right, let me help solve the problem. State, will you all put this outside your agreement, the no contact?
That's no objection.
All right, so any objection to the court correcting the paperwork to be no contact with the complainants, and that will be outside your plea bargain agreement?
No objection.
State any objection? State any objection? No objection, correct?
Well, Your Honor, and Ashley Jones for the record, for one of the witnesses, it's Andrea Salazar. That one we would ask be above the line and part of our agreement for a no contact order. And I don't think that there's going to be an objection from defense on that. Isadora, we can make the order.
Yeah, we can. That's acceptable. We'll go on with that.
Okay. All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting no contact with Isadora Balderas. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer to exhibit 1 with all attachments, Your Honor.
No objections, Judge.
All right. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
No.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation with testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
We are, Judge.
All right, state, have you had contact with your complainant?
We've attempted and didn't get any return, Your Honor. We had to leave voicemails.
All right, thank you so much.
Thank you, Your Honor.
Yes, anything you wish to say on behalf of your client with regards to the no contact?
Only he represents to me that they have an ongoing relationship. They've had one, and he asked me earlier, can I put her on my visiting list here in jail if the judge says no harmful contact? I said, yeah, I think so. And when you go to prison, you can put her on a visiting list if it's no harmful contact. So apparently there's an expectation from him that she will want to come see him. So I'm taking him at his word that they do have a relationship. I also, the phone numbers I had, I left messages and she did not call me back. So I'm trying to reach out to her also.
All right.
And also
Sir.
point out, this is a screwdriver, not a knife. It was swinging it around. It's a little bit different than.
All right. Sir, this is what the court is going to do. As previously stated, the court is finding you guilty. There's an affirmative finding of family violence. There's an affirmative finding of deadly weapon. There's to be no contact with Andrea Salazar and Isadora Balderas. Taking consideration 2024 CR 012198, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also an affirmative finding of family violence. You're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, I do.
All right, we can go off the record. Here's the thing. Anytime you're swinging a screwdriver at somebody or hitting somebody with the screwdriver, it gets to that point of violence in a relationship, not a good relationship.
Yes,
So your relationship with her is over. How old are you?
I am 43.
All right, so you should know better. So that relationship is over. Here's my advice to you. When you're released from the prison, don't immediately get into another relationship because you're not ready for one.
Yes, ma'am.
Buy yourself an orchid. And when you buy that orchid, it comes from the store, it's beautiful, the blooms are on it, right? It's sort of like a new relationship. Everything is new. Everybody's loving each other. The fact that somebody doesn't clean up behind themselves, you think that's so cute, right? Because it's a brand new relationship. Well, what you do is when you get that orchid, once the blooms fall off, and it will, do not get in a relationship until you're able to make that same orchid rebloom. Because when you try to get that orchid to rebloom, it'll teach you patience. Because no matter what you do, sometimes that orchid is just like, no, not blooming. You understand?
Yes, ma'am.
All right, good luck to you.
All right, thank you,
You're
John.
welcome. All right, so on this case, we're here for a violation report. Is that correct?
Yes, Judge. He had a PR bond on a PG 1 to 4 awaiting indictment.
Mhm.
And then he also had a less than 1 gram subsequent to that. He's on a PR bond for the first case and then the YSL bond company for the second case, to my knowledge.
All right, so state in regards to these cases that the court has for the violation report, it's for drug cases.
The offense
And the
date-
offense date is 2023. Have there been any labs?
Judge, I'm gonna check. I know on the newer case that, from 2024, I don't think we can have left, but I'm checking on.
In the meantime, could I tell you a little bit more?
Sure.
Yeah, Mr. Chavarria is working, he's 19 years old, correct? 18 years old, he's working at a car wash place, he gets $19 an hour. He paid for his bond, he got a PR bond for one, but he's been paying for his bonds, he's been checking in.
Okay.
He's made appearances in County Court 12, he's never missed a setting.
Okay.
And he's scheduled to be in County Court 12 next.
So why was he rearrested? Because the violation report I have, the only reason why you're here is because they said you were rearrested on the County Court 12 matter and then a drug case matter. And then,
Yeah, you guys-
sure.
And so we just received a draft on the 2023 case, like 5 days ago.
Mhm.
So I, will get one on indictment or attempt to do it myself.
All right, let's go just a moment. The same conditions. And then what we can do is we can recall this to see about the other cases, and maybe that may take care of everything. You understand?
Judge, I think that the reason for the violation report is because he was rearrested for a DWI as UCW and being arrested on February
Yes.
6th.
Yes.
So just given those facts, I mean, we would be asking for the bond to be doubled.
Okay, we can go on the record. All right. We're on the record in Night Mag number 743129. State versus Emmanuel Chavarria. Can I have parties announced for the record for the state?
State,
Defense.
Joseph Dateson.
And you're Mr. Chavarria?
Yes, ma'am.
All right, the court is in receipt of a first violation report and a second violation report. Based upon the violation report, it was filed due to your being rearrested on previous cases. And I'm assuming, since it says rearrested, he had made bond for those cases previously. Is that correct?
To my knowledge, he had made bond on all those misdemeanor cases as well.
All right.
He was already magistrated.
So, state, what are you requesting in regards to the violation report?
which is requesting that the bond double, I believe that it was 2,000, so we're asking for 4,000.
All right, defense.
Judge, my client's working. He's 18 years old. He can't afford to lose his job. He posted bond on his misdemeanors. And He has his mother here in the gallery who's relying on him to make house payments, utility payments. He does have one child who lives with him. He's not married, he has a girlfriend. One child is expensive and eats a lot, and he has expenses for child support, not child support. He doesn't owe child support. He's appeared in County Court 12 every time. He's never missed a setting. He checks in with pretrial. He's willing to report more frequently. He's asking if he could have his bond stay the same. And if not, have if we could have like a summons and have a pretrial setting to see about disposition within 30 days.
All right. And Mr. Chavarria, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Emmanuel Anthony Chavarria.
All right, on your bond for the driving while intoxicated in misdemeanor court, are you required to do any type of drug testing of anything of that nature?
Drug testing, what do you mean?
Your analysis. Does anybody test you to see if you're using alcohol?
My job, they do daily, like monthly drug tests and stuff.
All right.
If they see that you're acting weird, that they'll drug test you.
All right, so you're receiving drug testing through your work?
But sometimes just not.
All right, so my question is, you have cases in misdemeanor court. Do you understand that? One of them is driving while intoxicated, and I don't want to get into any of the facts of that case or what people think the facts are, but are they giving you any type of drug testing for that case? Do you have to urinate and have people check your urine?
No, ma'am, I haven't got drug tested for that case.
All right,
They took blood though, so they took blood out of me.
okay, that's related to something else, to see if you had alcohol in your system while you were driving. Have you ever used any marijuana in the past or anything of that nature?
It was like, when they had pulled me over, yes, ma'am.
Okay,
But not that day. I wasn't smoking or drinking that day.
okay,
I just had it in my possession.
okay. All right, so this is what the court is going to do. The court is not going to increase his bond. And I know judges are not supposed to tell why, but let me just tell everybody why I'm not increasing his bond. The drug cases have been pending since December 2023. The state only recently received the labs. And if either party wanted to, these cases could have been dismissed for further investigation under 32.01 of the Texas Code of Criminal Procedure. So I'm not going to increase your bond and state it. Of course, it's up to you whether you're indicted or not, but he's 18. He doesn't have any more money to afford any more bonds. What I can do is I can reset the night mag cases before you indict, if that's the route you choose. And defense, you and your client can appear. And if you all are able to reach agreement, then that's completely up to you all. If you're not able to reach an agreement, then we'll head towards jury trial.
I would like to have a chance to negotiate for resolution.
All right, so state, we can go off the record. State, are you in? I know he's going to ask for how much time?
Within 30 days.
All right, so he's going to ask for 30 days. Are you all going to indict that before 30 days or if?
No, I'll confirm that. Work towards resolution.
All right, so what we'll do is we'll recall this. Ms. Ferguson, if I could have a 30-day reset on Chavarria for the night mag cases. And they're going to ask for drug testing. I'm going to ask that the fees be waived based upon his finances. March 20th. All right, so we're going to come back on each of these cases on March 20th. And you work, is that enough time with your employer?
Oh, yes, ma'am. I'll tell them if I can get that day off.
All right, if for some reason you're not allowed to have that day off, counsel, he can appear by Zoom.
Yes, Judge. Thank you.
Is there anything else?
No.
No, Your Honor.
All right, thank you. Once you sign the reset form, you're excused. Court is calling 2024 CR 007-306 State versus Enrique Hernandez. Can I have parties announced for the record for the state?
Andrew Harris.
Right back there.
John St. Heinrichs for Mr. Hernandez.
And are you Mr. Hernandez?
Yes.
All right, and we have an interpreter present. If you could raise your right hand, please. Do you solemnly, do you solemnly swear or affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state for the record.
Carmen Tarragona Sykes.
All right, Mr. Hernandez, all of the documents I'm going to review with you are in English. Were those documents reviewed with you in Spanish?
Yes.
And counsel, do you speak Spanish?
I do not, Judge.
All right, and were those, these documents reviewed with him in Spanish?
They were, Judge.
All right. Mr. Enriquez, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it?
Yes.
And is there a discovery acknowledgement?
I don't think I've prepared one, Your Honor.
All right,
I can acknowledge on the record, Judge.
all right. Counsel, have you received all of the discovery?
I believe so, Judge.
And did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery, and state, I'll need that acknowledgement of discovery.
I will make sure you get it, Judge.
Right. Mr. Hernandez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do so waive the reading, Judge.
State, are you proceeding on the indictment as presented?
Yes, Judge, however, there is one issue that I wish to address.
Yes.
In clause number 581769, the judgment states that the defendant's name is Enrique Tadeo Hernandez. If you look at the SID number and the date of birth for Enrique Tadeo Hernandez, you'll find that they are the same. SID number and date of birth for Enrique Hernandez, indicted under this cause number and charged by information in 359671. So on those bases, we believe that they're the same person.
We have no objections with that finding, Judge.
All right, Mr. Hernandez, did you review the document entitled Court Admonishments and Waivers with your attorney? Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes.
All right, so here's the thing. You're gonna have to wait till the interpreter finishes interpreting. And we're either gonna speak in English or Spanish, and that's for you. So if you wish to speak to the court in English, then we will not have the interpreter. Do you understand?
Yes.
So do you wish to have an interpreter?
Yes.
All right. So do you understand you're charged with driving while intoxicated, third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? Yeah. And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, has your client had an opportunity to consult with an immigration attorney?
Yes, Your Honor. My client has had an opportunity to consult with his own retained immigration attorney, and I've explained, as I know them, the immigration consequences as well. to him accepting a plea in this case.
Mr. Hernandez, did you have a chance to speak with an immigration attorney on this matter?
Yes,
And were you able to discuss with your immigration attorney the impact this case will have on your immigration status?
yes,
And do you understand that by entering into a plea bargain agreement in this case, you may be deported and not allowed to re-enter into the United States?
yes,
Do you understand that you may be denied re-entry into the United States?
yes,
And do you understand that you may be denied naturalization?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
According to the plea, punishment is to be assessed at 3 years in the prison and the state recommends community supervision. Did you understand that to be the plea?
yes,
Defense, is that the plea?
That is the plea, Judge.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, have there been any such motions?
There has not been, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There'll be a TAP evaluation, 100 hours of community service restitution, 10 days in the Bexar County Jail as a condition of probation, ignition interlock for half the term, 2-year driver's license suspension, DWI intervention, and VIP live. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Seen in Exhibit 1 in attachments.
No objections, Judge.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments or review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
All right, state, with regards to the jail time, normally based upon the fact that there is overcrowding at the jail and other health issues, the court will allow the defendant to serve the 10 days on GPS. Do you have any objection to that in this case?
No, Your Honor. I also have no objection if the court wants to hold the 10 days in advance.
All right, thank you. You may be excused.
Thank you, Judge.
No objections, Judge.
All right, and anything you wish to say on behalf of your client?
Your Honor, yes, my client is not a naturalized United States citizen. I have concerns that if he is transported to the jail, he will be placed on an ICE detainer and removed.
All right, so here's the thing. This is what I tell people. I look at cases, Mr. Hernandez, on an individual basis. Based upon your status, I won't treat you any differently than anyone else. So, for example, if somebody were to tell me, oh, we can't reach this plea bargain agreement because if we do reach this plea bargain agreement, this person will be deported. In those cases, you know what I say? You either want a jury trial or you don't. So I believe that everyone should be treated fairly. Now, whether or not ICE detains you or pick you up, that is completely up to ICE. This is not a federal court, so I have no control over whether you're deported or not deported. This is just simply a state, I shouldn't say simply, but this is a state court, and I just review the cases that are before me. Do you understand?
Yes,
Now, do you have any children?
Sí.
yes.
And what are their ages?
20,
20,
17,
17,
12 y 6 años.
12, and 6 years old.
All right. And are you employed?
Yes.
And what do you do?
Construcción.
Construction.
Okay. All right, this is what the court will do. As previously stated, the court is finding you guilty. The court will sentence you to 3 years in the prison, suspended and probated for 3 years. There's regular reporting by Zoom or in person. Proof of employment within 30 days. There's to be no employment as a home care provider or with minors. Ignition interlock for half the term. There's to be a 2-year driver's license suspension. DWI intervention. VIP live. There's to be a TAP evaluation. Out of custody. Follow recommendations. There should be a referral to felony drug court. Field visits 1 time per month for 6 months. 100 hours of community service restitution. I'm going to order parenting classes. Once he completes parenting classes, that will be deemed satisfied. There's to be 20 days partial GPS. And that will be partial for employment only.
Thank you, Judge.
You're welcome. And there's to be 60 sober meetings in 60 days. Probation, is there anything else that's needed? Thank you. And regular and random UAs. Mr. Hernandez, is there anything else you need from the court to be successful?
I don't know.
All right. Well, if you find that you need some help maintaining your sobriety, just let the probation know. If you feel as though they're not addressing your issues, you can always come back to court. Do you understand?
Yes.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Normally, what I do say, if people are not here legally, I will tell them they're not allowed as conditions of their probation to re-enter the United States unless they do it legally. But your defense counsel has let the court know that you are actually here legally. So stay out of trouble.
Your Honor, I would like to also tender discovery.
All right, thank you.
Thank you, Judge. Your Honor, may my client be excused?
Oh, once he goes over conditions with probation.
Yes, Your Honor.
All right, thank you.
May I be excused, Judge?
Yes,
Thank you.
and thank you, sir, for dressing appropriately for court.
Thank you for the court's time today.
You're welcome.
Thank you.
You're welcome.
Thank you, Norma.
Your Honor, may I be excused after
Yes.
probation?
Yes, thank you.
Across these hearings, Judge Boyd shows 3 different sides of courtroom control. In the first case, she does not let a relationship-based plea turn into an excuse to keep the same door open. She draws a boundary and makes the message unmistakable. In the second, she looks past the surface of a violation report and asks whether the system is actually ready to justify a harsher bond decision. And in the third, she walks a defendant through the full weight of a felony plea, from supervision to sobriety to the long-term consequences of conviction. Different cases, different defendants, but the same courtroom lesson. Judge Boyd listens, checks the record, and then makes sure every person standing in front of her understands what happens next. For more real courtroom breakdowns, subscribe to Court Beacon TV.